Court delivers judgment in Nnamdi Kanu's ₦1 billion suit against FG July 1st. Listen to the news in full. A Federal High Court, Abuja, on Wednesday fixed July 1st for judgment in a ₦1 billion suit filed by Nnamdi Kanu, leader of the proscribed indigenous people of Biafra, against the federal government and Department of State Services. Justice James Omotosho fixed the date after Kanu's counsel, Alo Ejimako, the FG's lawyer, Mercy Akeredolu, and their counterparts with the DSS, AM Danlami, adopted their processes and made their submissions in the suit. The news agency of Nigeria, NAN, reports that Kanu, through his lawyer Ejimako, had filed the instant suit marked FHC ABJ CS 1633-2023 for the enforcement of his fundamental rights while in detention. In the originating motion, dated and filed December 4, 2023, the applicant sued the Federal Republic of Nigeria, Attorney General of the Federation, DSS, and its DG as first to fourth respondent, respectively. The suit was filed pursuant to Order 2, Rules 1 and 2 of the Fundamental Rights Enforcement Procedure Plans 2009, among others. Upon resumed hearing, Ejimako told the court that he filed an originating motion dated and filed on December 4, 2023. The lawyer said he also filed a further affidavit dated and filed March 26 with 6 exhibits in response to third and fourth respondents' counter affidavits. He said the exhibits had, among others, a certified true copy of a previous judgment. He said he filed additional further affidavits on April 22nd in response to the additional counter affidavit filed by third and fourth respondents dated April 18. The lawyer who adopted the document prayed the court grant their reliefs sought. Akeredolu, who held the brief of Maimuna Lami Shehu for the FRN and AGF, said in opposing Kanu's application, they filed a counter affidavit on April 12 with 1 exhibit. She said a written address, also dated and filed April 12, was attached with the counter affidavit. The lawyer urged the court to dismiss the IPOB leader suit. In the same vein, Danlami, who appeared for the DSS and his DG, told the court that a 15-paragraph counter affidavit dated April 12 was filed with same date with an exhibit. He said they equally filed a further counter affidavit dated and filed April 18 with 2 exhibits. He prayed the court to dismiss the suit for lacking in merit. After the proceeding that lasted till evening, Justice Omotosho adjourned the matter until July 1st for judgment. In the motion, the detained IPOB leader prayed for 8 reliefs. He sought a declaration that the respondent act of forcible seizure and photocopying of confidential legal documents pertaining to facilitating the preparation of his defense, which were brought to him by his lawyers, amounted to denial of his rights by the defended to be defended by legal practitioners of his own choice. He also sought a declaration that the respondent's act of refusing or preventing his counsel from taking note of details of counsel's professional discussions or consultations with him at DSS detention. This, he said, amounted to denial of his right to be given adequate facilities for the preparation of his defense by legal practitioners of his choice. He is also seeking an order mandating the respondents to jointly and severally pay the sum of 1 billion naira as damages for the mental, emotional, psychological, and other damages he suffered as a result of his rights breach. But in a counter affidavit dated and filed by the DSS on March 12, the security outfit denied allegations leveled against it. He averred that Kanu was in safe and secured custody of the DSS and is not detained in solitary confinement. He argued that the IPOB leader was permitted to interact and consult with his lawyers on his visiting days without any interference. He said at no material time did any DSS personnel seize or confiscate documents brought to Kanu by his lawyers or any other person. The official denied allegations that the personnel usually record their interaction during visits said there is no basis for eavesdropping and recording of their conversations. He said in line with the Service Standard Operation Procedure of the State Security Service, all visitors to our facility are subjected to normal routine security checks and items in their positions scanned. According to him, this is to avoid unauthorized materials making their way into the facility. Benye said the instant suit was an abuse of court process, Kanu having argued same issues before Justice Iyako and the matter reserved for judgment. The FRN and the AGF, in a counter affidavit, also urged the court to dismiss the suit for being an abuse of court process. And this is the news for today. Don't forget to like this video, comment under this video, and subscribe to this channel to get more news from this channel.